Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to talk about a video that got kicking around yesterday out here in the YouTubeverse. Got a lot of traction. It was by Brandon Herrera, who is an absolutely fantastic content creator. And I will remind everyone that he is running for United States House of Representatives, State of Texas 23rd Legislative District. We'll go ahead and link up his campaign website down below in case you want to show him some love. You're welcome, Brandon. But listen, it was a video, very entertaining video, as he usually does, about a suit over gun memes. Now, that caught my attention. I'm like, you got to be kidding me. I had an opportunity to go track that lawsuit down. I had an opportunity to read the complaint. And I got to tell you, there's a lot there, and none of it, and I do mean none of it, is intelligent at all. So today, let's break it down from a legal standpoint. Let's talk about the gun meme lawsuit is even dumber than you think. Okay, so the suit we're talking about today is the suit of Lowy v. Daniel Defense et al. Et al is a fancy Latin way of saying a whole bunch of other people. And there is a whole slew of named defendants, including 17 separate companies associated with the manufacturing of firearms or firearm components, 17 different companies, plus 20 other individually named, currently named as John Doe defendants. Now, this involves a horrific incident that occurred back in April of 22. That was when Karen Lowy, who went to go pick up her child at Edmund Burke Elementary School in Washington, D.C., was shot, as were numerous other people, by an individual who had taken position across the street and was basically acting as a sniper that day. Unfortunately, Miss Lowy was severely wounded twice. She nearly died, however, was able to make a somewhat recovery from her injuries, obviously with long-lasting and permanent effects. Nobody here condones the activity of what occurred that day. What Miss Lowy and her attorney has done, and I'm a little surprised, I'll be honest with you, I'm a little surprised an attorney actually signed this complaint. I'm not going to name the lawyer. I am going to link the brief up below so you can look up the lawyer for yourself. But to say that there is a ton, and I mean a ton, of salacious and ridiculous allegations in this complaint would be an understatement. Essentially, what plaintiffs are alleging here is that this entire shooting was created by all of these companies and the manner in which they marketed their material. Now, I know it was kind of simplified as, well, they're suing over gun memes, and I'll show you where that is in the lawsuit. That is true, actually, but they're suing over a lot more. None of it makes the lawsuit have any more legitimacy. In fact, the more you read it, the more you want to roll your eyes or grab a barf bag. But let me break it down for you so you can understand what salacious allegations are being made here by the plaintiff. Okay, right out of the gates, when we start looking at really early on in the complaint, we see that the plaintiff alleges the following. For years, these manufacturers have deceptively and unfairly marketed their assault rifles, rifle accessories, and ammunition in ways designed to appeal to the impulsive, risk-taking tendencies of civilian, adolescent, and post-adolescent males, the same category of consumers defendants have watched time after time commit the type of mass shootings that unfolded again at Edmund Burke School. The plaintiffs further allege, with full knowledge and appreciation of their role in facilitating these mass shootings, defendants continue to intentionally and recklessly advertise, market, promote, and sell a warrior mentality that a certain subset of youths, like this shooter who live-streamed his crimes, fantasize will make them legendary. Defendants have not even taken the simplest steps to prevent or discourage young, impulsive would-be mass shooters from acquiring their weapons, weapon accessories, and ammunition and using them to inflict harm, such as implementing age gates on their social media accounts to align with any state and local regulations governing the age at which a person could purchase or use the relevant products, warning consumers about the dangers of assault rifles, or even avoiding advertising illegal modifications to and use of weapons defendants' practices are negligent and unlawful. Now, there's even more, because the plaintiff continues to then state, each defendant enabled the shooter to carry out the shooting. They knowingly sought to place their weapons, accessories, and ammunition in the hands of disturbed young men by targeting and exploiting risk-seeking and often troubling desires of these consumers. Oh, and the allegations include even headings in the pleadings such as Defendants Daniel Defense, FAB, BCM, SOLGW, Fostech, Griffin Armament, and Centurion Arms design and market weapons of war to civilians. Wow, that is an amazing allegation. Oh wait, there's even more though, because it gets crazier, including, despite knowing that mass shootings have been repeatedly perpetrated by young men armed with assault rifles, defendants specifically and intentionally market their weapons, weapon accessories, and ammunition in ways that appeal to adolescent and post-adolescent males, including through social media and innovations of other brands geared toward children and young adults. They have taken no steps to guard against the sale of their weapons, weapon accessories, and ammunition to those who would foreseeably commit such violence act, and in some cases have even gone so far as to ridicule the idea that their advertising should not promote and encourage violence. Oh, but wait, see, the plaintiff's ire doesn't just go to all of these defendants. They go to all of my YouTube colleagues and everyone else out here, because the plaintiffs also allege defendants are not alone among gun industry companies in adopting this marketing strategy. A 2020 study of gun company and influencer content on YouTube and Twitter found that military, patriotic, and law enforcement themes were commonplace, and glorification of military gun use was easily found in contemporary gun advertising. So yes, it is anything that is pro-military, pro-police, pro-self-preservation, pro-self-defense, pro-United States, pro-Constitution is obviously dangerous speech. Okay, and then as you can see, the plaintiffs went through a very long process of cutting and pasting into their pleadings dozens and dozens of advertisements in which they took exception to. And yes, amongst them were some memes by certain gun manufacturers. That is why this is called the gun meme lawsuit. But there was actually a lot more to complain about. But ultimately, the plaintiffs come up to this conclusion. Defendants' strategies appear designed to exploit adolescents and young adults' attraction to impulsive, thrill-seeking behavior and their insecurities about their futures. And they are eerily reminiscent of the historical practices of the tobacco and alcohol industries and other industries that have exploited young consumers' vulnerability by designing advertisements that promote thrill-seeking and self-esteem inflating conduct in order to hook them early and convert them into lifelong purchasers of their products. And then specifically related to some of the memes, this is what the plaintiffs allege. Defendant SOLGW has also incorporated misogynistic jokes into its promotion of illegal firearm activity. In 2022, as Canadian officials considered firearm restrictions, SOLGW posted the following image. And as you can see here from this image, it's a funny little meme. But hey, that's not going to stop the plaintiffs, because they got more beefs, including, and in reference to a possible modification to make a weapon fire as fully automatic, defendant SOLGW posted a picture of a lower receiver, which the shooter purchased from SOLGW's brand, with the caption, and then as you can see, this is the caption here. Hey, probably not the way we're going to market Washington gun law, but that is the way this company chose to market their product. Plaintiffs also allege the shooter had 3 fully automatic weapons at his disposal on the day of the shooting. Now, I don't know if that's true or not, but considering how old the shooter was, considering when this event took place, we could be certain of one thing. If, in fact, the shooter was in possession of 3 automatic weapons, he was in unlawful possession of those 3 automatic weapons. Listen, not only does plaintiff's attorney here want to make all of these salacious allegations, apparently they also want to play armchair psychiatrist, because also included in the allegations is decades of scientific evidence demonstrates that the onset of intense thrill-seeking urges associated with puberty outpaces the development of the area of the brain responsible for judgment and impulse control, which continues into young adulthood. Okay, but here's the thing, and this is where all of this falls apart, and it's right here in the plaintiff's own pleadings. You see, because there is a civil rule, we all had to learn it in law school. Professor Hess, I remember this. Civil Rule 12b-6 that is when one side can move to dismiss the claim because the complaining party, in this case the plaintiff, has failed to state a cause of action upon which relief can be granted. And you see, here's the thing. Even if you accept an arguendo that all of these companies have engaged in all kinds of salacious marketing, okay, all kinds of over-the-top marketing, here's what's not alleged in the complaint. What's not alleged in the complaint is that the shooter viewed any of this material. As a matter of fact, the only thing that the complaint says is the following. Upon information and belief, the shooter assembled defendants' products to create customized weapons of war for use in the shooting. The shooter's online presence suggests that he did so after searching online for how-to instructions and instructional videos. And they also point out, upon information and belief, the shooter was exposed to and influenced by defendants' deceptive and unfair marketing acts and practices while researching and planning the shooting. So the plaintiffs are saying that when the shooter decided to go online and start doing research about how he was going to shoot up a school, that's when the deceptive practices took over. But let us not forget that what plaintiffs said is that the shooter was already online looking to do this activity. So the bottom line is why many of these allegations are completely salacious. And this lawsuit, if it were to gain traction, has a significant effect on many companies' First Amendment rights. And let us not forget that companies are also afforded First Amendment protections. Not quite the same as what individuals, but quite similar, okay? This lawsuit has the potential to have a devastating impact. But despite all of these allegations, the plaintiff has not proven in any shred or iota of evidence that there's a causal connection between the marketing and the shooter's activities. And therefore, there will probably be a very quick motion to dismiss this lawsuit. The case, once again, is Lowy v. Daniel Defense et al. We'll link up the complaint down below so you can geek out on yourself. It is a case about gun memes. It's about a lot more, and it's also about a whole lot of nothing because they've never connected the complaint to the criminal activity. If you got any more questions about this case or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, let's everyone remember then that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.